So you're heading to family court, probably on your own, and you've got this mountain of proof. But the big question is, how do you get a judge to actually look at it? Well, today, we're going to break down that exact process, step by step.
Look, you've got it all, right? The text, the screenshots, the emails. You know you have the proof. But there's that pit in your stomach, that fear that you're going to walk in there, try to explain everything, and just get ignored. That your truth won't count because you don't speak some kind of secret legal code.
Okay, let's just cut right through all that anxiety. The secret to being heard in court isn't having a law degree. It's having a system. Seriously, when you're organized, it sends a powerful message to the judge. It says you're credible, you're prepared, and you're here to talk about the facts. And that's the system we're going to build right now.
We're going to follow a really simple 4-part roadmap. First, we'll map out our game plan. Then, we'll get into gathering the proof. After that, we'll build a case file that looks totally professional. And finally, I'll show you exactly how to present it all with confidence.
First up, the evidence game plan. Look, before you start printing a single thing, you have to know the rules of the game. You've got to know what a judge actually considers real, valid evidence.
So, what's on the list? Well, it's the concrete stuff you'd think of. You know, texts, official reports. But check out that last one, your own testimony. That's huge. It means your story, the one you tell under oath, is also powerful evidence. The key here is that every single piece, whether it's a photo or your own words, has to be directly relevant to your case.
And just as important is knowing what to leave out, the stuff that's just noise. Judges are trained to tune out something called hearsay. Basically, it's secondhand info. If you say, well, my sister told me she saw, nope, that's hearsay. The judge needs to hear from your sister. The same goes for your opinions. You have to stick to the facts, the stuff you can actually prove.
Okay, now we know what to look for. Let's move on to part 2, gathering your proof. This is where we get practical and create a master log to keep track of everything, just like a lawyer would.
This right here, this is your new best friend. It's your master evidence log. It looks simple, but it's an absolute game changer. You've got the date, what happened, but look at that third column, court order violated. That's the secret sauce. You're not just complaining about something, you're showing the judge exactly which rule was broken. That's everything.
And here is a pro tip that is absolutely crucial. Document everything the same day it happens. I'm serious. When you log something right away, it tells the judge this was a big deal to you from the start. If you wait weeks to write it down, it just doesn't seem as urgent or, frankly, as credible.
Okay, so you've gathered all this great proof, you've logged it all. What now? Well, in Section 3, we're building your case file. This is how we take all that raw info and turn it into a polished, professional toolkit that's ready for court.
You've basically got 2 choices here, a physical binder or a digital folder. If you're going to court in person, you can't beat a good old-fashioned binder. No tech glitches, easy to hand over. For virtual hearings, a super organized digital folder is your go-to. Whichever you choose, the goal is the same. Make it clean. Use tabs or really clear file names so you can find anything in a heartbeat.
Now this might be the single most important page in your entire file. It's the exhibit index. Think of it like a table of contents for your case. It goes right at the very front, and it gives the judge a perfect roadmap of your argument before you even say a word. Just the exhibit letter, what it is, and a quick sentence on why it matters.
All right, you've done all the hard prep work. That brings us to our final step. And yeah, it's usually the one that feels the most intimidating. Presenting like a pro. Let's make sure all this amazing organization pays off when it really, really counts.
Before you even think about handing anything to the judge, I want you to burn one number into your brain. It's simple, it's easy, and it is non-negotiable. That number is 3.
It's called the Rule of 3, and you just have to do it. You need 1 full copy for the judge, 1 full copy for the other person or their lawyer, and 1 full copy for you to work from. Why? It's about fairness and keeping things moving. Everyone sees the same thing at the same time. It shows the court you respect the process.
So, how do you actually introduce one of these things? It feels like you need to know some secret handshake, but it's really just a simple 4-step dance. You get the judge's attention, say what you've got, explain why it's important, and then you ask for it to be officially included.
And here are the magic words. Seriously, you can write this down on a sticky note and just read it. Saying it this way: Your Honor, I offer Exhibit B. I move to admit Exhibit B. It isn't about being fancy, it's about being clear. It tells the judge and everyone else in the room that you know what you're doing.
But wait, what if the other side suddenly yells, objection?
First thing, don't panic. It's totally normal. Just be quiet, look at the judge, and wait. The judge will make a decision. They might ask you why your exhibit is relevant, and all you have to do is calmly explain it, just like we've been talking about.
So on the day of your hearing, just run through this quick mental checklist. Exhibits are labeled and organized? Check. Got that index at the front? Check. You have 3 full copies ready to go? Check. And here's the final boss test. Can you find any single document in less than 30 seconds? If the answer is yes, you're not just hoping to be heard, you are ready.
And that's really it. You've taken what was probably a big, chaotic mess of frustration and turned it into a clear, compelling, professional case file. You've done the work, you've built the system, your evidence is officially judge-ready. So the only question left is, what story will it tell?